Chapter 33, Uttering a Forged Document. Section 580. Definition and Essentials. The crime of uttering a forged document is offering a forged instrument as genuine with knowledge of its falsity and with intent to defraud. The instrument offered must be a forgery. It must be offered as genuine. The person offering it must have knowledge of its falsity, and he must intend to defraud. At common law, uttering a forged document is a distinct misdemeanor. Section 581. What constitutes an uttering? To constitute an uttering, it is not essential that the forged document be actually received as genuine by the party upon whom the attempt to defraud is made. Exhibiting a forged receipt for inspect is sufficient. In such a case the defendant, who was a stonemason, had purchased stone to the amount of some £5. And payment had been frequently demanded and promised. Finally he claimed that he had paid the bill to the former manager of the quarry and produced a receipt for the same purporting to be signed by him. He was requested to deliver the receipt but refused to do so. Subsequently he was convicted of uttering forged paper, and on the question being reserved the 11 judges were of opinion that proof established an uttering. To utter a forged instrument is to declare or assert, directly or indirectly, by words or actions, that it is good. It is not only a sale or paying away a counterfeit note or endorsement, but obtaining credit on it in any form, as by leaving it in pledge, or indeed offering it in dealing, though it be refused, amounts to an uttering and publishing. Presenting a forged deed for record, aiding to get a forged will probated, recording a forged discharge of a mortgage, exhibiting a forged receipt by a proposed surety to establish his credit, pledging a forged document, offering a forged check, have all been held to come within the scope of this crime. And it has also been held that to offer a check, payable to the order of a third person and not endorsed, constitutes the crime. Having in one's possession forged notes with intent falsely, fraudulently, and deceitfully to utter and pass the same for and as true and genuine notes is not a crime. The allegations amount only to an intention to cheat, which at common law is not indictable. It has been held that knowingly having in one's possession a box containing counterfeit coins, and the delivery of the same to a common carrier, consigned to a man in another city, is not a crime. In the case cited, the defendant delivered a box containing 2,800 counterfeit shillings and 1,000 counterfeit sixpences to a coach officer for carriage to a man in Glasgow. The box was stopped, however, at the place where it was received, and the court held that the act was not a sufficient uttering to make it a crime. But a mere silent offer to pass a document which is known to be a forgery is sufficient. So is mailing a forged document for delivery in another jurisdiction. In England, and also in this country, statutes have been passed which make having in one's possession a forged document, with intent to pass it, a crime. Scienter may be proved by evidence of other crimes of a similar nature.